Welcome to our webinar on HIPAA and mobile health applications. My name is Kim Canonson, and I'm a partner in the healthcare group at McGuire Woods. I focus my practice on regulatory and reimbursement issues affecting our firm's healthcare clients, including HIPAA and state privacy law issues. With me today are my colleagues Sarah Shanti and Sarah Mick, both of whom also routinely counsel our clients on HIPAA and related data privacy and security issues. We have quite a bit of material to cover today, so we may not have time for questions. However, we absolutely encourage you to submit your questions during the webinar in the Q&A text box, and one of us will get back to you to discuss your questions after the webinar concludes. Now I'd like to give a brief overview of today's agenda. We will begin today by talking a bit about the proliferation of healthcare-related apps, and as well as the ramifications of that growth for health information privacy and security. We will then provide a very short, high-level refresher on HIPAA and talk about the OCR's guidance applicable to apps and app developers. Then we're going to talk briefly about other relevant privacy and security laws and other healthcare laws that impact app developers and apps. We will then conclude with some practical tips regarding how to mitigate risk and how to enhance compliance. With that, I will turn it over to Sarah Shanti, who will begin the discussion.
Thank you, Kim, and thank you for joining everybody on the phone. Easy for you to remember today that Sarah Shanti, which is myself, and Sarah Mick, who will be chiming in shortly, are the presenters. So pretty easy to remember names today. The slide right now that you're seeing is just a brief overview of the agenda that Kim mentioned. And I'm just going to dive in right now into kind of an industry status report almost. So healthcare apps are breaking through, certainly. We're seeing that they're very popular, more popular than ever, and only growing. Last year, there was an estimated about 300,000 healthcare apps out there, which was a vast increase over the prior years to that, and we know that it's only growing in 2018 and beyond. Notably, even though there's so many apps, we're finding that the most popular apps are really kind of monopolizing the industry right now. In 2015, we have a bullet here just noting an interesting statistic that just a few dozen of the apps accounted for nearly 50% of all downloads. So we're seeing that when an app becomes popular or gets traction, it really can quickly blow up. And that's really important as we talk about some of the security and privacy risks where popular apps are breached or become more vulnerable to breaches because they are so popular, and hackers and other wrongdoers kind of know that there's a vault of information in those more popular applications. Right now, the app market is estimated to be almost $30 billion, which seems like a huge number, but considering that the projected growth is about 25% per year moving forward, we're looking at over $100 billion in the next 5 years. So certainly we understand that this is really only going to grow and build, and really important to understand when creating an app or using an app or facilitating an app between relationships, how important these can be and the regulatory risks that attach. What's really driving this is what we kind of call a little punny, the couch patient, right? Not the couch potato anymore, but the couch patient, the patient that is focused on wellness and wants to be healthy. In fact, they're not sitting on the couch watching TV, but they also don't want to take time out of their busy, beautiful lives to actually go to the clinic. So they're engaging from their couch or from their home, and that's really driving the apps. And of course, artificial intelligence, which we're not going to talk about too much today, but certainly we understand that those results and how that's growing and becoming more confident in the industry, that's really facilitating a lot more of the app as well. I know Sarah Mick is going to be jumping in and describing some of the regulations today, specifically HIPAA, but we did want to note that with the popularity, privacy and some of the regulations are really important too, because we understand that agencies, government officials, litigators are all looking at these as kind of a potential risk and in some cases an opportunity. So HIPAA certainly may govern the privacy, security, and any breaches of these apps, depending if if it is subject to HIPAA, which Sarah Mick will describe in a little bit. State laws are certainly becoming much more active in wanting to protect their constituents and their constituents' data. FTC doesn't want to be forgotten either. They prohibit deceptive and unfair trade practices, but also where there's an app or something that represents a certain privacy standard, security standard, if that's false, the FTC certainly wants to get involved. Just a side note as well, where there's a personal health record, which will draw a distinction between that and a designated health record under HIPAA later on, but a personal health record is really something that an individual patient maintains for their own behalf. They don't necessarily need it from the provider or their medical facility. So where I, Sarah Shanti, am kind of keeping track of all my records separate from my physicians, that might not be governed by HIPAA unless my physicians are helping manage it, but certainly if there's a breach there, the FTC would be the enforcement agency as opposed to HHS. So this slide is here for your reference if you need to recall who enforces when it's not HIPAA world. And FDA also regulates certain applications that meet the medical device definition, which we've provided here. As Kim noted, because there's so much interesting information in this webinar, we're packing it in. I'm going to move on to the next slide and just talk about some of the breaking new apps, something to kind of look forward to so everybody kind of knows what's going on in the industry moving forward after today. Despite that, there are so many applications and there's so many individuals and entities involved in the creation and facilitation of these apps. The insurance industry hasn't really gotten too involved yet, but they're looking to. So we're looking forward to kind of seeing how they're going to handle their apps, and especially with some of the mergers and acquisitions between healthcare insurers and some of the pharmacy benefit managers and even pharmacies. We're seeing that those applications are probably going to get really interesting and become very popular very quickly, and they haven't even really started that rollout. And what we're calling the young baby boomers, which we're not exactly sure what some of these articles mean by that, but we certainly know that there's a huge targeted group in the baby boomers for healthcare, and the app world is really trying to make those accessible to those that have a little bit of tech savvy in them. Some of the hot trends moving forward, I'm sure a lot of people on the phone are familiar with Fitbits and some of the apps that kind of monitor whether it's your diabetes or your steps per day or your diet, but applications in healthcare are getting much more sophisticated. We're finding that there's a lot more apps trying to create a secure texting module between patients and physicians, between patients and therapists, and even patients and pharmacy and pharmacists. So we're seeing those are becoming much more prevalent and accepted, and patients are really getting excited about those too, where they can text their pharmacist instead of even having to get in the car and go through the drive-through anymore. Optical scanning applications where you can kind of scan your retina or scan a facial feature and use that to either track your eyesight or another ailment. And we're finding that's really interesting. And retina scans in many cases and many times are considered at the HIPAA level and at the state level biometric data that needs to be protected. And home testing. We're going to see a lot more of this in the future, where you kind of log on and say, these are my symptoms, and I think I might need a test or two to figure out exactly what's going on. And you almost order the test, take the blood sample, the urine sample at home, send it back in through the application, and you're kind of a home lab all of a sudden. So all of those things are really going to push regulation too. Big data, of course, since these are so prolific, we're finding that people are, of course, going to want to take advantage for big data analytics and marketing purposes, making HIPAA compliance and data privacy and security even more important. And we're interested to see what happens with blockchain. Blockchain is certainly becoming something that we're hearing a lot about and sounds great in theory, and even at the technical level makes perfect sense, but seeing how we can pull that into applications and healthcare data will be really groundbreaking. So just some things to think about where the app world is going. certainly we understand that there are breaches. That's one of the main vulnerabilities when we talk about privacy and security is the data being breached and someone who's not authorized to get the data, receiving the data. We're seeing that happen through wearables like your fitness tracker and certain other things that we're finding, apps that, work well with blood pressure cuffs or a scale at home, things like that. Breaches of those devices is certainly a concern. Under Armour, who purchased the MyFitnessPal app a few years ago, and their connected healthcare is about 1/3 of their business, had a huge hack, I think it was earlier this year, at the end of last year. Obviously, the breach notifications happened in this year. I think it was uncovered that the breach happened a little bit before those notifications went out, months actually, and 150 million people were affected. And I think the results of that breach are not fully known yet. Under Armour tried to be very clear that Social Security numbers were not involved, but certainly email addresses and the health data was breached. And so even though there might not be clear identity theft, certainly individuals might be susceptible to marketing or different viruses that they otherwise wouldn't be. And then we're finding that consumers are kind of in the middle of a finger-pointing game sometimes when it comes to applications, depending on what the app is if there is a breach or if it was not secure, who's responsible? Is it the app developer? Is it the physician who engaged the app developer? Is it they didn't read their privacy policies, they didn't choose the correct privacy options, and so we're finding that consumers are kind of in the middle of this. They have to be a little bit diligent themselves to protect themselves, but at the end of the day, we know that the deep pockets are kind of always where the biggest scrutiny is, which certainly is usually not the patient. And then we're just seeing that these wearables and these applications are being used not only by patients, but by health departments, law enforcement, national security agencies, understanding that sometimes these apps can be used for a positive. Many people are probably following the Molly Tibbetts tragedy and being able to locate her and track her a little bit through the Fitbit that she was wearing. So sometimes it can be used for a very wonderful purpose. Otherwise, we're finding that some health apps are being created in response to health epidemics. For example, dating sites have surged STDs in a lot of urban areas, and county health departments and other entities are trying to use new apps to kind of track down those partners or educate, identify symptoms, things like that. So some of the public health concerns that are created by certain other apps, healthcare apps are trying to rectify. So that's kind of the current status. Kind of exciting, kind of terrifying, certainly manageable, and Sarah Mick is now going to kind of get into exactly how we can manage some of those risks.
Yes, thank you, Sarah. There are a lot of different privacy and security risks that exist right now with mobile medical apps. Many of them are familiar concepts that we've seen long-standing under HIPAA and other various privacy and security frameworks like encryption, disposal issues. Others are, familiar concepts with a new twist. For example, loss, theft, and hacking. Previously, we might have seen something more so in the physical domain of an actual device, whereas now we might be looking more so electronic or data itself. And then there's some concepts that are even more novel, like inadequate default privacy settings on an app or device when it goes to the consumer. So I guess now we'll start and do a quick review of the HIPAA and the HITECH Act. It's a long-standing older law that's now being applied to newer technology as things are evolving. It was first signed into law in 1996. The published final privacy rule came out in December of 2000, and the security rule in February of 2003, so that was a pretty long time ago. Then in February 2009, Congress passed the HITECH Act, and the intent of that was to broaden and increase the scope of HIPAA in terms of privacy and security enforcement and breach notification. In 2013, there was a lot of activity in the HIPAA realm with the publication of the HIPAA final rule, which was intended to implement the HITECH Act. And the aspects of HIPAA and HITAC that we most commonly deal with are on the slide right here, the privacy rule, which deals with privacy rights and addresses use and disclosure of protected health information. Security rule requires the adoption of administrative, physical, and technical safeguards to protect ePHI. Breach notification, which dictates what types of notifications must be provided when there's a breach of unsecured PHI. And enforcement, the civil money penalties and federal criminal penalties when there's a violation of HIPAA. So HIPAA, a common confusion is who must comply with HIPAA, because it's not necessarily everyone, although it does end up being a broad universe frequently. To begin with, there has to be a covered entity. And under HIPAA, there are 3 classes of covered entities: healthcare providers, which are your typical hospitals, laboratories, pharmacies; health plans, so health insurance issuers, Medicare Parts A and B, Medicaid, employer-sponsored health plans; and then healthcare clearinghouses, which are typically billing companies. If you're not a covered entity, you may be a business associate of a covered entity, and that's an individual or entity that provides services on behalf of a covered entity or another business associate. So you can have a subcontractor business associate within the chain that require the entity to create, receive, maintain, or transmit protected health information. So OCR, and Sarah Shanti will talk a little bit more specifically about the different roles within the mobile apps and how that it kind of fits into the schema with the definitions of business associate and the implications when HIPAA is triggered. HIPAA, OCR, the Office of Civil Rights, is the enforcement agency for HIPAA, and has developed a very useful mobile health developer portal website. And on that website, they began in February 2016, with the release of the Health App Developers as Business Associates Guidance. It's actually titled Health App Use Scenarios in HIPAA, and it addresses a number of different scenarios and it addresses 2 key questions. How does HIPAA apply to health information that a patient creates, manages, or organizes through the use of a health app? And when might an app developer need to comply with the HIPAA rules? And it basically says, even if you're not a covered entity, you may be a business associate if you're creating or offering this app on behalf of a covered entity or one of the covered entity's contractors. And that this guidance in and of itself, it addresses the developer. But it's important to also remember that when you're the covered entity that's transmitting the PHI in the first place, you still have the obligation to implement reasonable safeguards to protect PHI, and nothing within the analysis of what the developer is going to do is going to relieve you as a covered entity of your own independent obligations with respect to HIPAA.
And that talks a little bit, Sarah, right, about the difference between an app developer that's engaged for the purpose of just creating an app, just generally,
right,
versus kind of hosting and managing some of the data or storing some of the actual patient information, right? It kind of distinguishes between those 2 roles of a developer and when it would be governed by HIPAA.
Right, exactly, because going back to that, you need a covered entity involvement directly implicated in order for HIPAA to be triggered in the first place. So, for example, your example that you provided was a great example of maybe a developer developed an app and someone happens to be using it of their own accord, going into the patient portal, pulling the records, storing it, making notes on it. That would not implicate HIPAA necessarily, versus the healthcare provider has engage that developer to create that app and work with them and the portal to interface, that would be implicating HIPAA in that situation.
Okay, perfect.
And then there's a number of other guidance that OCR has come out with, including guidance on cloud provider services, and essentially this basically states that that it governs the use of the storage, maintenance, and transmission of electronic PHI in the cloud, and clarifies the fact that, covered entities and business associates, they can use mobile devices to access PHI in the cloud as long as appropriate physical, administrative, and technical safeguards are in place, and that it's no different than any other type of storage, and the rules would be applied in an analogous manner, essentially.
Sarah, can you just re-explain to those that are not very familiar with what PHI means versus just patient information? So PHI, can we talk just a second about the definition of what PHI is? So HIPAA, as you kind of described, only governs covered entities and business associates that have PHI, right? Kind of those two elements have to be met. So how does someone know if they have PHI as opposed to just personal information? Oh, sorry. I just want to make sure that we're getting the definition of PHI out to the audience. And I think it's important to understand, and we'll talk about this in a little bit too, but before we move on, just clarifying that the source of the personal information, the personal health information, is notable. So providers and health plans that have that information or create that information based off of healthcare, past, present, or future healthcare, that's considered protected health information under HIPAA. So if you're an entity governed by HIPAA and have that kind of data, then it's governed by HIPAA. Where an individual is creating, kind of a log of all their ailments and putting that into an app that's not facilitated by the provider, because the source of that information is not the covered entity, it would not be governed by HIPAA, correct? Because we don't have the covered entity involved or a business associate involved, and also because the data wasn't created by them, so it's not currently governed by HIPAA.
And that's really something that HIPAA, when it was originally enacted and when the rules were originally promulgated, didn't specifically contemplate. The idea of a personal health record came along a little bit later because back in 1996, people weren't creating electronic personal health records. And so the distinction that Sarah and Sarah are drawing is really important, and it's driven further by the proliferation of all of these apps that allow individuals to carry around on their cell phone all sorts of information about their fitness and about their health more specifically.
Perfect.
Yeah, and then there's a bunch of other nuances that come along with that in terms of if it's encrypted, is it still potentially a PHI if I am storing it on my database and I'm the cloud service provider? And the answer to that is OCR came back with and said, yes, it is. However, if when you, cloud service provider, receives that information and it's been fully de-identified, that's a different story.
Mm-hmm.
So there's a lot of different nuances in terms of the application.
Mm-hmm.
Something interesting that OCR has been trying to do with their portal is try and make it a little bit more interactive and elicit feedback from consumers and developers and other users of the website in terms of what they need guidance on. And so they have opened up this submit and view questions section and divided it into two categories of answered questions that OCR has actually responded to, although it's not legally binding guidance. It's useful in an interpretation as it relates to developers. And then questions that have not yet been answered but that others have commented on. And there's also a long-running HIPAA Q's portal notes, and that's actually what it's called. And it not only tracks what OCR is doing in this field with developers, but it also tracks what other agencies are doing and kind of OCR's thoughts on that. And so it's one kind of consolidated place to get a lot of good information. And we have the link for that right there. Additional OCR guidance, there's a plethora of it. That's available is the cybersecurity newsletter, and we've included a couple examples on the next slide, so I won't go into that. Some other fact sheets on mobile devices and PHI and ransomware, and then other additional references and cross-references to specific key publications by other agencies, like the National Institute of Standards and Technologies cybersecurity framework for assistance in compliance with the HIPAA security requirements, and the FCC guidance, which Sarah's already discussed. What's interesting in this field too is that with these newsletters, OCR has made a commitment to come out with like new and updated information on a pretty regular basis. At this point, there have already been a number of newsletters on hot topics in 2018. So many that OCR has already archived the cybersecurity newsletters from 2016 to 2017, which just really shows that it's a really rapidly evolving field. In addition to HIPAA, which governs protected health information, which we had all just kind of discussed and discussed the nuances of that, there are a number of other laws that address privacy and security matters that relate to mobile health applications, one of which is Part 2, 42 CFR Part 2, or SAMHSA, which governs substance abuse programs. Typically, it's a lot more stringent than HIPAA, and there has been like a big push to kind of reconcile the two. So it's putting HIPAA at the forefront.
Sarah, can you explain why an app developer would care about SAMHSA?
Well, currently, yes. There's a big push right now in terms of the opioid epidemic and a lot of the other substance abuse issues that are going on right now, and a need for a free transmission of information, which is not necessarily possible with SAMHSA and some other treatment alternatives that would use mobile devices have been implemented or are attempting to be. The next is eavesdropping and wiretapping laws, which govern audio and video recordings. So, for example, in a telehealth situation, whether or not that session can be recorded and whether it would implicate any of these additional laws. And then there's a number of state laws, because HIPAA sets the floor, but not the ceiling. And so states can adopt laws that are more strict than HIPAA, and we're starting to see that across the board.
And a lot of these laws, let me know your thoughts, Sarah, can be overcome with proper consent or authorization from the patient or the patient's representative, correct?
Right.
So, and we haven't seen this yet, but certainly something to consider is an app can certainly build those consents and those authorizations, making sure that, where the law permits disclosure or use upon consent, that it's not necessarily a black box that you can't get the data out. You just have to do it by usually one of the law's exceptions, which are pretty specific. Is that right?
Definitely. I would say it's a highly regulated area by a number of different laws, and planning on the front end, it relieves a lot of headaches on the back end. Definitely. So next, we'll just talk a little bit about enforcement. In terms of enforcement, OCR has a number of different options in addition to just the general reputational and public relations implications that could potentially result due to a HIPAA violation. There's also the possibility for civil actions and criminal penalties. In terms of civil actions, there's a broad range of different enforcement actions that can occur, just a complaint that ends up being dismissed, a resolution agreement, which is the settlement agreement with the government, additional monitoring of the settling party, and civil money penalties, which is kind of at the top tier level. There have not been that many cases of civil money penalties, but there is a recent case that is of interest here that involves the U.S. Department of Justice and Texas MD Anderson, and so the OCR was investigating the center after there were 3 reported data breaches involving an unencrypted laptop and 2 unencrypted USB circumstances. And like we had talked about before, this is a situation where what we're looking at is really physical, but it's easy to see how this could also be in a different situation, more so like a hacking or a ransomware or any of those other types of scenarios. And here there was kind of a disregard, and the items were unencrypted, and there was a failure to follow the policies and procedures, which is what had resulted in the $4.3 million civil money penalties that were ultimately upheld by the ALJ, administrative law judge.
Just one comment there on civil actions. So there is no private right of action under HIPAA, and what that means is that an individual cannot bring a lawsuit against a covered entity or business associate alleging violations of HIPAA and recover personally. And this would be relevant in a case where a covered entity had its own app, or an app developer was actually functioning as a business associate of a covered entity, and there was some sort of a breach involving the data stored in that app. That having been said, there are state common law invasion of privacy claims that can be brought, and then as Sarah was just articulating, the OCR has a lot of different weapons in its quiver to force an app developer or a covered entity to modify its behavior, both through the imposition of civil monetary penalties and by entering into a resolution agreement, which is a monitoring agreement. And covered entities and business associates alike have had to enter into pretty onerous monitoring agreements where their policies and procedures are subject to scrutiny by the OCR, have to be approved by the OCR, and these agreements can be as short as 1 year or as long as 5 years. And so the community of parties that need to worry about this is, of course, expanded now that you have cloud providers and app developers who qualify in certain cases as business associates of covered entities.
That's perfect, Kim. And I would just chime in that, we've seen some recent activity from the FTC. We noted earlier in our slides, FTC might have some enforcement ability for personal health records when there's a breach, where HIPAA does not have that authority. But both HIPAA and FTC, as of today, because the court didn't address the question of dual jurisdiction in the latest LabMD ongoing saga. But right now, where HIPAA does play a role and has jurisdiction, the FTC also does. There's nothing to state that if you have breach or you don't have policies, you're misrepresenting that you're secure and you're not, that the FTC couldn't also come in and deem that unfair and deceptive practices. So, and like we said, FTC is looking to not be forgotten here. So, having certain privacy policies and keeping true to those representations is really important, not only from the HIPAA perspective, but as Kim noted, state law enforcement and FTC, and we're seeing civil actions too. So HIPAA is kind of maybe almost the base, kind of, minimum, make sure you're doing these things because it could quickly snowball from the enforcement perspective.
Definitely, and we have been seeing it actually snowballing in a criminal way as well. There's actually been some jail implications. More recently, there was instances of insider theft in 3 separate cases, like twice in 2018 and once at least in 2015, where an employee was terminated and illegally accessed the Google Drive in one case, and just the general platform in the other cases, with an intent to use the information for personal benefit, and ended up with jail time, or will likely end up with jail time at this time. And then last, the question has kind of been also in this regulatory climate where regulations are being de-emphasized. The question is HIPAA enforcement winding down at this point? Because we saw in 2016, $23.5 million in settlements and fines with 13 enforcement actions. In 2017, it was still pretty hot with 10 enforcement actions totaling $19.4 million, but it's been a lot slower so far in 2018. But the general thought at this point is it's a little too early to tell, but that does not necessarily mean that enforcement is winding down because investigations take a significant period of time, and in addition, it's a 6-year look back. So with the new administration looking back at what was occurring while all these laws were still in place at this time, it's feasible that there could be more activity coming down the pipeline. Okay. I think we had already talked about California's data privacy law, and that Sarah was going to talk a little bit about the European Union and GDP creep.
Yeah, so we noted that in addition to HIPAA, there's state laws that are more restrictive, and we're finding California has gone even one step further in passing a bill just this year, about a month or two ago, called the Consumer Protection Act, which is similar to the GDPR, which is the EU privacy rule, which got a lot of attention this past year because it became effective. But it's been on the global radar for a long, long time because it's much more restrictive than U.S. privacy laws. So we're seeing that the states aren't waiting for the U.S. Federal government to take action. The states are really finding, especially California that has such a huge tech industry, is finding that they really want to protect their constituents, their citizens from misuse of data. And one of those things is kind of the right to be forgotten. So we all know right now, or as one of my good friends just learned the other day at dinner, when you delete a tweet or you delete anything kind of from your applications or your email, that's not necessarily gone forever. There are so many backups and servers, and you know, those things don't necessarily just disappear into the ether like we'd like. And so the EU has understood that, you know, with certain information, you have a right to be forgotten. That data can be deleted permanently, and no one has a backup. Certainly that's not necessarily the case with an official medical record, things like that. But we are seeing where states are getting much more involved, where hopefully the data will become more and more secure and can be deleted and modified more permanently. But in the meantime, outside of California specifically, because California law, of course, may affect many, many companies, but would really only impact or be able to be enforceable for the constituents of California. But I think we're going to see states take a much more aggressive action after California, that this data can be protected and can be exchanged more freely, and patients have more of a say in how it can be protected and used. So just kind of something to be on the lookout, that HIPAA, we know HIPAA is going to change in the future. You know, there's no eminent date of that right now, but we certainly know that it's a law that needs to live and grow with technology. So we almost encourage looking at your state laws and seeing what the states are doing, because they seem to be a little bit more in the now with regard to immediate action and enforcement. So we know we've thrown a lot at you so far. We've kind of given you a high-level kind of environmental report of healthcare applications. We've talked a little bit about what HIPAA is and what HIPAA can do. We've probably scared you a little bit about the enforcement actions that are out there, but now we're going to try to tie it all together for you. So when you're using an application and what application is subject to what regulation is really dependent, and I invite Sarah and Kim to chime in because this is not easy stuff here, but it really is dependent on what activity is happening, what data is at issue, and who is using and viewing the data. So it's not always crystal clear if every app is governed by HIPAA or every individual who logs in is governed by HIPAA. It's not even as clear as every provider who has health information through an application is governed by HIPAA. So we're going to try to talk through just a few examples, some generalities. Our emails are at the end of this presentation if you have any questions today or ever. But because HIPAA governs covered entities, which in short are providers and health plans when there's personal health information involved, and because they say it's more than just protecting it, you need to have policies, you need to be training your workforce on how to protect the data, you need to be doing risk analyses, and we know this isn't a HIPAA presentation exactly, so we want to make sure that we're not getting too deep into the nitty-gritty of HIPAA, but HIPAA is more than than simply protecting it. It's showing that you're protecting it in lots of different ways. So to be HIPAA compliant, you do need the policies, you need the training, you need to be showing that you're assessing your risk. If there is an impermissible disclosure or use or access, that you're properly rectifying that and providing notifications. So when we say HIPAA compliance, there's a lot there to have a compliant program, as I'm sure many of you on the phone are probably only too well aware. But where HIPAA does come into play, those are the things that you need to have a compliant program. So now the question really is, okay, but when does it come into play exactly? So where a provider, for example, a hospital, has created an application for their patients. So a clinic may say, here is an application that you can download, Patient Smith. You can use it to change your appointments. You can do it to log on and look at your labs. You can do it to have a virtual clinic appointment with us, where essentially a telemedicine appointment, where the provider is offering that application and receiving and generating personal health information for the patients, and submitting claims certainly for those services. That's absolutely governed by HIPAA. So all that information going back and forth, governed by HIPAA. That's maybe a more straightforward case. Where the individual has, decided that here's my Fitbit, I got it for Christmas from, a significant other, and I'm tracking my steps, I'm tracking my sleep, I'm tracking my diet, my sugar intake, things like that, and that then if they're completely maintaining that kind of world of information on their Fitbit, not sharing it, that's not governed by HIPAA. If they share it with their significant other, if they share it with their athletic trainer at the gym, still not governed by HIPAA, because we don't have a covered entity or a business associate involved yet. So even though that is health information, it's not governed by HIPAA.
But what it is it's a personal health record, like you were discussing earlier, and comes within the province of the FTC and is governed by that regulatory scheme.
Yes, thanks, Kim. And perhaps depending on the state that they're in, also state laws. Certainly, states are, although HIPAA is not so specific as to distinguish between sensitive health information, such as maybe a woman's health issue or STD, HIV, HIPAA kind of says, health information is health information. We don't distinguish between how high level or how important it is or how sensitive it is. A lot of states do. So states might say any HIV, depending on your state, HIV data, no matter who has it, if it's anything to do with an individual's HIV status, it's somehow protected or restricted. So we certainly defer to states on some of those mental health and women's health and sexual health standards. Support groups. So Sarah Mick had described about the opioid crisis, and there's so many more therapy apps and substance abuse apps are becoming very, very, very prevalent, and a lot of times those are shared with a sponsor or a support group, and again, not governed by HIPAA unless they're sharing it with a drug program, an official, like a Betty Ford is a prime example, or with their physician. The physician knows that they have an addiction and is kind of monitoring them. When that physician gets that data, because they fall under HIPAA, as soon as they get that data, they need to protect that data, even though it came from a non-HIPAA protected source. Caretakers, guardians, things like that. Generally, if it's an individual maintaining their data and sharing it with those individuals, not governed by HIPAA. If I'm somehow incapacitated, knock on wood, and I have a caretaker who represents me, and they share some of my health information with my physician, now that health information that's been given over to the physician, again, is covered. And of course, we just wanted to bring in the business associate level as well. So where the app, for example, the virtual clinic application, where it's the provider who's saying we want to offer this application, it's going to be tied to our electronic medical record, it's going to be great, where they engage a third-party vendor to create the app. And they say, just create an app, you don't need any data to do it, just maybe beta data that's not based off of any real patient. Make the app, then hand it over to us, and we'll run it. That app developer, because they're getting no patient information, even though they're engaged by a covered entity, not covered by HIPAA. As soon as the provider says, hey, we want you to create this app, also run it for us, store the data on a cloud, help us with maintenance of this application. We don't know IT, we don't have our own IT department, help us with that. Then the app developer, because they were engaged by a covered entity and are receiving or accessing the patient health information, now they too are governed by HIPAA and need to have a HIPAA compliance program. Kim or Sarah, anything to add to help clarify?
No, I think that was a very well drawn distinction.
Okay, great. I know this is not easy stuff. The next slide here, we kind of try to talk about 3 pockets of main healthcare apps and kind of the users and the initiators. So we are seeing a lot of providers are getting kind of tech savvy, which is fun, wanting to spread the telemedicine opportunities. They want to they want to be able to pull your Fitbit data in, or they want to watch some of your live monitoring, dialysis patients, cardiac patients. A physician, as busy as they are always taking the time to get more data and wanting to see how their patients are doing outside of their brick and mortar walls. And so they're really welcoming, give us your data, let's see what's really going on with you so we can help you. And a lot of times they just want to access that information. They don't really want to keep the information or pull the information into their EHR. They just want to look at it and be done. So if they're just viewing it, of course, they can't go to the bar or can't go to happy hour later and talk about it, but they certainly don't need security around that if they're simply viewing it off of the patient's iPad or something like that. As soon as they're pulling it into their system, though, that's when we need some security around that PHI. And we're also seeing that they're really trying, and this goes hand in hand with the 21st Century Cures Act, which is really pushing interoperability between applications and electronic technology. And so we're seeing that, everybody wants big data because they feel that they can get to the root of the patient's issue much quicker. So we're seeing more interoperability. We're seeing apps now really be an app for other apps to be interoperable with, kind of saying use our app and then we'll be able to link you with other apps. And it's really becoming a wonderful network, but you do have to be careful that you understand what data is yours, what data you want to keep yours that you don't want disclosed further, and how to secure the data that you're responsible for. Patients are getting even more tech savvy. In addition to all the wellness, the exercise, and the prevention apps, the stress management apps, I'm sure a lot of us are familiar with those, the 5-minute meditation apps, those things are all considered healthcare apps, but are not governed by HIPAA generally because it's just the end user and the application have an agreement to, have a relationship, and you're not really bringing that into the professional provider world or the health plan world, where your health plan says, hey, we'll give you a discount if you're, doing best practices, you're going to the gym or whatever a couple times a week, and then you say, yes, I'll prove that. If we prove that, I'll prove that by showing you, my application. I put in 1,000 steps yesterday, or you can see that I registered with the gym. Then once that health plan or that provider gets the information again, they have to protect it, but they don't have to protect the entire app that they're not responsible for. Personal health records, we've talked about that a few times, where patients are becoming more aggressive and saying, I have a lot of health records out there. I want to maintain them. I want to aggregate them. I want to be able to present them to a new physician. So while they're maintaining their own health record, HIPAA might not apply, but as soon as they share that and a provider covered entity or health plan covered entity or their business associate accepts that information, again, upon acceptance, now those entities need to protect it. And we're also seeing some really cool things happen with clinical conditions, chronic disease, diabetes management. Blue Star is the app that I believe was the first FDA-approved app where, it was really involved in treatment. It was not just monitoring sugar flow. It was really helping treat the patient and have the patient understand what kind of needs they need to meet. Substance abuse, as we noted, women's health. We're seeing a lot of pregnancy apps, especially first-time pregnancy, high-risk pregnancies, where Instead of calling your physician every 5 minutes, you have an app that they're also able to check. So if there seems to be a crazy amount of weight gain within a very short amount of time, or high blood pressure, where you are linking the app to a blood pressure cuff or something like that, and the physician can simply, kind of watch, like, okay, nothing, no problem, we're watching, we're monitoring, no issue, and then as soon as it kind of hits a red flag, now we can have an appointment. But as opposed to, women going in every 5 minutes and dealing with that commute and waiting room and everything, it's a nice flow of information, but the physician and those apps might be governed by HIPAA. And then third parties, we're seeing, it's a very commercial area right now where third parties are saying, hey, look what we can do for you. If your physician gets on and you get on patient, we're going to make everything so seamless and easy for you. And it seems such a good idea in theory, but again, they have to make sure they're meeting certain FDA, FTC, and possibly HIPAA, depending on their relationships and what data they have. A lot of this has to do with, kind of monitoring real time, even during, something as serious as a brain surgery, real-time monitoring and remote monitoring is becoming more and more prevalent. And so where those apps are getting that information, even though they might not have been engaged directly by a physician, they have to consider if they're now having to safeguard that information under federal or state law. And I think we're doing okay with time. So the next slide is kind of on your, we made it just so you know that we're all aware we don't live on a HIPAA island, although that would be a fun place, I'm sure. That there are a lot of other healthcare laws and corporate laws and things like that that impact these applications. Just a few, in creating an application or working with an app developer, you want to think about corporate structure, professional licensing. Certainly you want to make sure that the app is not violating any corporate practice and medicine laws, right? Things like that they're not holding themselves out to be giving medical advice without professional licensure. We talked about FDA, FTC, fraud and abuse laws. Certainly we have to be careful for kickbacks, things like that. When an app sounds maybe too good to be true, or is a free trial, or goes to a patient free, let's make sure that we're in the confines of fraud and abuse world. Contract, IP, some of those fun ideas too that we just want to make sure is on your radar. So this slide, feel free to ask us any questions about these pieces too, but just something to consider as you use your apps or create your new apps. Finally, maybe this is the most important slide. We'll just take a few minutes to go through. We were talking here at the table before we joined that a lot of applications are very aware of HIPAA. They kind of say all the right stuff, that we're HIPAA compliant, that we protect your privacy, we care, now buy us for $5.99, right? And so just be careful that HIPAA does not have any sort of HIPAA certification. OCR does not HHS OCR does not recognize any sort of HIPAA certification. There's no stamp that you can put on an app that says, oh, we're in the clear for HIPAA. And so that's great if they're acknowledging that they are HIPAA compliant, but a HIPAA cert is not something that the government recognizes. So also just be cognizant that you might have to ask some follow-up questions on that. Really, the best thing to do is make sure you're educated on what you have to do to have a secure application or be working with a secure application. Train your workforce. I'm going to let Sarah take over in just a few minutes. But one thing I wanted to note was outside of training and kind of creating some secure confines, one thing that we're seeing providers do more and more, and health plans perhaps will do this too, is in wanting to get big data, in wanting to go to their patients and say, send us your Fitbit information, send us your, your steps that you've been tracking, send us your sleep log, a list of your prescriptions that you're keeping in an app. Even though they want that, it's certainly risky to just insert all of that, pull it all into the EMR. And so we're finding one interesting thing that's becoming more and more, I think, common is having kind of a silo outside of the EMR and saying, okay, let's upload your data, patient, into this silo. Our IT people, our records people will kind of siphon through it, choose what we want, and then pull it over into our EMR in a secure fashion and delete the rest of the stuff so we don't have a lot of extraneous information.
Right, definitely. And as most HIPAA programs, privacy measures, security measures, having robust policies and procedures in place, but then not just having those as dusty binders on the shelves, but implementing and updating them as times change and your technology changes, and monitoring and auditing what is occurring in the organization kind of on a daily basis with the app, and if HIPAA is applicable to you, limiting third-party access to people that are business associates and have written business associate agreements in place, which is a requirement for the transition of the PHI to the business associate. And generally speaking, just encouraging patient diligence in terms of consents and privacy settings, and keeping an open line of communication with that respect, which is also governed in large part by FTC regulations.
And one thing I'll just add in terms of best practices is, if for those covered entities on the phone, if you are going to be engaging with an app developer and that app developer is ultimately going to become a business associate, you want to do due diligence on that entity, because as a business associate, that entity has to comply with HIPAA in the same way that you do as a covered entity. They have to have done a risk assessment. They have to have policies and procedures. You want to make sure that they don't have a negative enforcement history. There's a lot of competition out there, and there's no reason to engage with a vendor that is not compliant, because it just puts you as a covered entity in jeopardy. Simultaneously, as an app developer, if you are going to have a subcontractor that is going to have access to the PHI that you're storing or maintaining, if you in fact are doing that, you want to make sure that that subcontractor is also compliant. So I think we're now at the end, and I want to thank you all for attending. Again, please feel free to email any one of us if you have questions about what we talked about today, or any other questions about HIPAA, data privacy, or data security issues, and we will get back to you promptly. So thank you all very much again, and have a nice afternoon.